Yes, sir. Oh, hold on. We want to make sure we have you on tape. All right, let's proceed.
Mr. Chief Justice, and may it please the members of the court, my name is William Adams. I represent the defendant, Jose Negron. This is an appeal from the denial of a Rule 30 motion to dismiss or to correct an illegal sentence on the grounds of duplication. How we ended up in this court was we asked the court to consider a line of cases, an overrule line of cases, which have been evolving in the appeals court, which hold in essence that if one pleads guilty, one thereby waives the right to challenge a sentence imposed on the grounds that it's duplicative. The two cases in particular are Mazzantini and Buckley. They were included in the addenda of the brief.
Basing that on the is this Brose or Broche?
Broche or Brose?
Okay.
I'm not sure.
But you don't seem to disagree with the Commonwealth in your analysis of Broche.
We do seem to agree pretty much.
Yeah.
And what we're saying basically is what the other state courts have said, construing Brose, and also what the federal circuits have said construing Brose, by and large. There are some exceptions. The Seventh Circuit, for example, has some variations. But by and large, our principle is that it's first of all, Brose does not control because it's a federal case on a procedural point not involving any federal point of law. And also that the cases, a very consistent course of cases coming right up until Mazzantini hit the docket, makes it pretty clear that one can always challenge a sentence on the grounds of duplication if one is simply relying on the record before the court and existing law. And in fact,
assuming you can, the Commonwealth points out that the argument about duplicative sentences is simply incorrect on a Mori analysis.
Well,
even if we don't need federal law, let's just go to state law. How do you prevail?
Well, I prevail on the point. Well, I think if I'm reading, it's based on the Enos decision, which is the only decision that there is that I can find, which discusses this specific issue. And the court there, the appeals court, did not indicate on what it was basing its analysis, like to say that the parties correctly agree or concede or whatever, that in fact these offenses are duplicative. The appeals court, I think, was relying on the two cases it cites, which are Kuklas and Jones, both of which did Mori analysis and then said, but we hold as a matter of statutory intent, even though a Mori analysis doesn't strictly control, it was not the legislative intent to punish for both offenses. And I'm basing this on the citations themselves in both cases. It covers the whole of the Mori analysis in Kuklas and also in Jones. And then the portion where the court says, even so, we think as a matter of legislative intent, it was not the legislature's intent that one be punished for committing both offenses in these circumstances. So that would have to be the approach I do, because I think it's true that Mori, applying a straight mechanical Mori analysis, Enos would have to be wrongly decided, except that doesn't seem to be what the appeals court used to decide it. And that's really kind of the issue for the court, whether you want to stay with cases like Kuklas and Jones, saying even if that Mori analysis doesn't work through enough indications of legislative intent, that the legislature did not intend duplicative punishment, therefore we're not going to enforce it. And I think that's basically what you have to say or come up with. My own view in this is that Enos has been on the books since 1988. The legislature has never acted to change it or alter it in any way. Another thing is that on the facts, the same policy interests are involved. Protection of the domicile, right of self-enjoyment, security, and all of that in both statutes. And also, insofar as the focus the case is on the assault, which is in fact assault on an occupant, was in the heading of the indictment for this particular count, to avoid invasions of the personal integrity of occupants of domiciles. So this is not really an instance where there are different public policies that the statutes seem to be invoking. They're invoking the same policies and the same kinds of interests. I remember a couple of Justice Graney's decisions where he was pointing out that one of the reasons we rely on the Maury rule is because when the legislature defines offenses differently, although they apply to the same unitary conduct, it's because they have different policies they're trying to promote. In this case, both statutes promote identical policies.
Well, except, as the Commonwealth argues, one of them comes out of a chapter that's really dealing with protection of property interests, and the other comes out of a chapter that's dealing with violations of the person. So aren't they in some ways doing different policies?
Well, and I think it's the same policy. It's a question of emphasis. And the other place where it plays out is what would be the unit of prosecution.
I'm sorry, what would be the
unit of prosecution? Because if it's considered an assault statute, in its basic emphasis, the unit of prosecution is each person assaulted. Whereas if it's, I think it's Commonwealth versus Gordon was the appeals court decision that decided this thing in 1996. If it's the
property?
The burglary statute, it's the breaking, regardless of how many people are assaulted. That's the unit of prosecution. In this case...
Well, under the armed burglary statute, you don't even need to approve an assault. That's one
No,
way
you
of
don't.
approving, but you don't even need to approve an assault.
You don't have to. I'm just saying that in this case, it resembles Commonwealth versus Gerald Walker, which was the case where the question was one involved sexual assaults, one statute said the proof had to be the person was under 14, one the person was under 16, and this court said it doesn't make a difference, even though technically the elements are different, because if the proof actually shows the person satisfies both, we're going to treat one as a lesser included of the other. So I see it as being somewhat analogous since the same interests are involved. Assaults are the gravamen of the Commonwealth's case, the way they're putting it in, and in fact, the statutes on the facts parallel each other. I mean, it's applied to the facts that are being argued. Any more on that aspect? Do you want to hear anything about the business of Brose and all of that? Have any questions in that direction?
Well, your point about Brose, or Brose, I'll use that, is we don't need it, and it's federal law, and we're fine the way we are.
We don't need it. I think, well, we don't need it. This court has already applied it. I mean, it's basically what the court actually did in Kuklus, the seminal duplication case, without actually saying this is the approach we're using. And in fact, in one of the appeals court cases, Arriaga, which is frequently cited, was also an appeal involving convictions entered on guilty pleas. So, I mean, there's this clear precedent. The kind of odd thing in Mazzantini was that the case was on all fours, both procedurally and substantively, regarding the offenses in Kuklus, and the appeals court just sort of ignored all that.
Oh, I see.
I mean, the same offenses were involved, and it was also a collateral appeal from
It was also
convictions.
marijuana? Wasn't Kuklus
It wasn't
marijuana?
marijuana. The statute at that time simply said narcotic drugs. And then when the statutes were amended, the only provision to be carried forward on the provision having to do with knowingly being present where a drug is kept, the only portion was heroin specified. But otherwise, the statutes are virtually identical, but I think it was...
I take it your argument is that Mazzanti is simply wrong to the extent it suggests that Brose changed our law, right?
Yeah, it's wrong. It's incredibly wrong, and it was carried forward in Buckley too. And the Commonwealth does mention a couple points that other courts have taken up. One is, aren't we really destroying the bargain If the court says, well, we don't have the authority to impose duplicative convictions in this case, are you really destroying the bargain if part of it's predicated upon there being convictions for two offenses? Knight, the Washington State case that I cite in the brief, deals with that, points out there's really a distinction between bargaining for a guilty plea, which they get, even though the court doesn't have the authority to do ultimately everything they wanted. They distinguish the agreement, the plea agreement, if you will, and from what exactly what the court is able to do, because all plea agreements are always subject to whatever external pressures or whatever external limitations there are based on the court. Another case that talks about that, which is cited in the brief, is the Colorado case, Patton, P-A-T-T-O-N, addresses the very same issue and comes to pretty much the same conclusion. All right, any other questions? In that case, I'll rest.
Thank you.
Thank you.
Chief Justice Ireland and members of the court, Catherine Robertson on behalf of the Hampden District Attorney's Office and on behalf of the Commonwealth this morning. And I am here to argue, the Commonwealth is here to argue that these offenses are not duplicative under the controlling cases of Vick and Morey, notwithstanding the appeals court's decision in Enos, which was a 1988 case. And you look at, under Vick and under Morey, you look at the elements that are required to be proved under 266, Section 14, and under 265, Section 18C. And if there is an element that's required to be proved under Chapter 266, Section 14, that's not required to be proved under Chapter 265, Section 18C, and there's an element under Chapter 265, 18C that's not required to be proved under 266, Section 14, then neither is a lesser included offense of the other, and it's appropriate for both convictions to stand.
I agree with you. Now tell me again, which is the element that doesn't...
Sure. Certainly, Your Honor. Under 266, Section 14, which is the crimes against property,
Right.
the armed assault in a dwelling.
Don't tell me all of the elements, just the
the
one.
distinguishing-
266-14 is the burglary.
Okay, I'm sorry.
Armed burglary.
Armed burglary, right. With respect to armed burglary, the defendant must must enter the dwelling with the intent to commit a felony therein. The requirement is that the intent exist at the time of breaking and entering the dwelling. He has to do that with
Has
an
to
intent.
break, too, doesn't he?
He has to break.
It's not just enter.
It's not just enter, and there's no requirement for breaking under 265, Section 18C. But the intent has to exist at the time of breaking and entering the dwelling. Under 265, Section 18C, the intent requirement, the requirement is that he or she, the defendant, commit an assault while armed in the dwelling, and that the assault in the dwelling be committed with the intent to commit a felony. That is a distinguishing, the scienter element is the distinguishing element between these two offenses. That is the element that this court relied on in Vick to distinguish the two offenses in Vick.
So Brose is irrelevant to this case.
Your Honor, I agree that Brose is irrelevant, and I also agree with Mr. Adams that that the appeals court's application of Brose has been overly broad. I think that the Commonwealth does agree with Mr. Adams in its...
You mean in Mazzatini and Buckley?
In Mazzatini and Buckley, in the sense that it appears that it's a very qualified waiver, or a very qualified or limited waiver that's established in that case. If, as in this case, as Mr. Negron's case, if his claim of duplication is based purely on the indictments and the contents of the plea colloquy, then there's no question under Brose and under Massachusetts law that he's entitled to make that claim. And so you really don't ever reach the case of Brose. And I think particularly in Mazzatini, it does appear that the appeals court has offered sort of an overly broad has relied on an overly broad application of that case.
What is the, I should know this, but is there, what's the status of Mazzatini and Buckley? Do you know?
Further appellate review was denied in each of those cases, Your Honor.
Ooh, okay.
Yes, that is the status of both of those cases.
Now, I gather it's also your argument that the armed burglary here could be complete simply by being armed in the house without there being an assault.
That is correct, Your Honor. The Commonwealth has done what Justice Cipher refers to as arguing a belt and suspenders approach, and that is even if these offenses were to be found duplicative, the judge, the motion judge, the plea colloquy judge heard enough to conclude that they were distinct acts that would support each of these convictions. In other words, once the indictments are pled in the alternative, as they can be, and once Mr. Negron broke and entered into this house with the intent of committing a felony, that is sufficient to commit a violation of that statute. He then has to move on, doesn't commit a felony under 265-18C until he actually commits an assault in the dwelling while armed, which is threatening this group of people, to try to steal money from them. He breaks and enters with the intention of stealing money from the inhabitants. That's a violation of 266, Section 14, then goes on to threaten the inhabitants while armed, and that's a violation of 265, Section 18C. I mean, with respect to Mr. Adams' contention that we're not protecting different interests here, there is a quite substantial body of case law, certainly the Levia case, which has been decided by this court, that recognizes that cases that are under Chapter 265 and that are crimes against persons protect a different interest from cases that are brought under crimes that are listed under Chapter 266 that are protect the integrity of property. If the court has no questions, I think I have made my points.
Thank you.
Thank you very much, Counsel.
Thank you, Your Honors.